If you've been in business, then I'm sure you've heard that it's important to keep accurate wage and time records. But what does that actually mean? And for how long do you need to keep this information? And what information do you legally need to keep? In this Back to Basics episode, we're going to take the conversation all the way back to understand wage and time records. Because the last thing that you want to do is to be scrambling when someone comes knocking at your door. Hi everyone, welcome back to Lawlands. My name is Sanam and thank you so much for tuning in today. Yes, my voice is sounding a little bit different and it is because I have been battling the flu for the last week, but I have come out on the other side from feeling like this was it, that there was no hope, no light at the end of the tunnel. I am here to say that there is light, people. I really thought that I had COVID or something because this was the worst that I had been sick in years. So no, it was no joke, people, no joke, but we are back at it and I'm glad to be back behind the mic again. I thought that this would be a great back to basics episode, like I said in the intro. It'll be a nice one to get a bit of a refresher and to understand the why. So this is for anyone that is in the HR space, that's a manager, that's a leader, that's an employer who needs to know this information because this is really critical. It doesn't only affect the people that own a business or the employers, the managing directors. It affects everyone in the business. And if you're a manager, if you're a leader, this will absolutely impact you because you need to make sure that your leave records and all of the information that you're putting through the system is all correct because it can matter on a bigger scale if something goes wrong or if the employer raises any concerns about it. Before we get into it, I just wanted to say thank you so much to everyone that's been listening to the episodes. If you love what you're hearing, then don't miss out on any of the future episodes. Hit that subscribe button and follow us because I'm here to help you stay informed and to make sure that you're in the loop when it comes to employment law. Let's kick things off by having a look at the reason why wage and time records are important. Now, we know the stock standard answer when you're thinking about the worst case scenario and you think everything's running smoothly, all of a sudden you've got an employee that turns around and says, hey, look, I think what's in my payslip is wrong. This wasn't done correctly. All of a sudden, now you've looked into it, employee and you are not on the same page, employee goes and complains to the labor inspectorate, and now Bob's your uncle, you've got a massive issue on your hands. So to avoid all of that, what do you do? The best thing to do is to have accurate and very detailed wage and time records. It's about ensuring that you're not avoiding the situation. I see that way too often with wage claims. It's usually on the part of the employer that one, they either don't have accurate records, meaning that they don't really have a proper record system, or they're just running payroll, but they're not really factoring in all the additional things. So they're just running payroll as if the person's on a salary. What ends up happening with a lot of wage workers is that they might work on a public holiday, and now all of a sudden it's time and a half and a day in lieu, which hasn't been factored. There's so many variables that can come up when you look outside of a standard 9-to-5 employment relationship. And that's where wage and time records are really important because it's usually everything is all great until one, someone comes knocking from outside, or two, the employee kicks up a fuss or has an issue about something. And you may be wondering, what part of the law are we talking about? It's all about section 130. And 132 I want to throw in there as well. So 130 is your main section in the Employment Relations Act. And what this basically says is that an employer has to keep wage and time records for each employee. Now, tricky, also very interesting. Yes, you have to keep wage and time records. Yes, you need to provide this to the employee ASAP when you get a request from the employee to produce these wage and time records. But where it gets interesting is that technically, legally speaking, there is no requirement under New Zealand legislation anywhere, and I mean absolutely anywhere, there is no requirement that an employer has to provide employees with regular pay slips. Yes, if the employer requests it, then under the Act, yes, you have an obligation to provide this basically ASAP. But if you haven't provided the information, then know that it is not a legal requirement Where it does become a breach is when the employee requests it and you can't produce it, or if a labor inspectorate comes in and you can't produce it within the time frame that's been imposed there. Let's talk about what is the actual requirement. So the requirement under Section 130 is that the employer needs to keep wage and time records that has the employee's name, their age if they're under the age of 20. Other than that, it will be postal address, type of work that they're doing, if they're in a individual agreement or under a collective agreement, the hours that they've worked, the wages that were paid, and any information around leave that was taken. All of that information needs to go into their pay records. And it needs to be something that is easily accessible, and it needs to be written down in a way that can be easily accessed. So that could be electronic form, whatever is a way to recall that information very quickly if it needs to be. Now, this information, it needs to be kept with the employer for 6 years. So 6 years, the employer needs to hold these records. And if the employer does not maintain these records, then there are penalties that can be imposed by the Employment Relations Authority, or a labor inspectorate may also want to take action and go down the path of penalties as well. Now, what does that look like? Section 132 of the Employment Relations Act outlines the consequences for employers who fail to keep or fail to produce accurate wage and time records, which is a requirement by the law, as we can see. In essence, what this section is doing is it puts the onus on the employer to see if they can prove that the wage and time records are actually accurate. So it shifts the burden of proof onto the employer. That's a really big thing. And under Section 132, what this means is that the authorities' response and the way that they handle these wage claims that come up is that they would essentially take the employee's word for it unless the employer can prove them wrong. So it's really important for employers to understand that not only is the weight of keeping these accurate records on the employer, but the weight of proving that these records are accurate and that the employee hasn't actually worked more hours, or that public holidays were paid correctly, or that sick leave was paid correctly, all of that information, that is all on the employer to be able to prove. And you may be wondering, oh my gosh, how do I go about this? This is crazy. It honestly is as simple as making sure that you have your processes in order when it comes to your payroll. So if you have a good clocking in, clocking out system, if you have a good process or system in place which makes it very clear that once an employee puts in their hours, it can't be changed, and also that there is a very clear expectation that employees go home, that there's been no hanging around and doing extra work. Now, in terms of why we also need to make sure that this information is all in order and is all accurate and correct, is because one of the things that was introduced earlier this year on the 6th of January was the worker protection legislation that came out, specifically around migrant worker exploitation, but it covers all employees as well. Now, in that, one of the things that came up was that if an immigration officer or a labor inspectorate comes into the premises and they request documents using their powers that they have, then the employer has 10 working days to respond to that request. And that also means providing wage and time records. It's really important that this is in order, because if it's not, then what ends up happening is penalties can come up. The penalties across the board are $1,000 per offence, New Zealand, and up to $20,000 within a 3-month period. And the Employment and Relations Authority can also award a penalty of up to $20,000 against a company. How can I make sure that I keep my records in order? Like I said, 6 years is the time frame. So you need to make sure that you're using accurate payroll software, that you're keeping this information in a place that can be easily accessible. Don't let it go into a place where it's hard to find the information. And you've got 6 years, so you've got to keep wages, time recordings, that means holiday pay, leave that's been paid, leave records, all of that information. And all of that has to be kept either electronically or somewhere where you can access it really easily. Psst. The secret is electronic. The last thing that you want is to be digging up stuff and trying to find things when they're all hidden away in a filing cabinet somewhere. So just keep that in mind. And I would say, aside from that, making sure that you keep the information for only the period of time that's needed. This is something that a lot of people don't actually talk about. In employment law, you don't have to deal too much with privacy, except for maybe initially in the recruiting stage. But other than that, you never really revisit it as an employer. I always like to talk about it because it's really important, and it's one of those pieces of legislation people generally tend to forget. And here as well, under the Privacy Act, you're only meant to keep employees' personal information for as long as the information is needed and for as long as it serves a purpose. You need to make sure that you offboard that information and that you get rid of it and you delete it. So in some cases, having certain information like tax records or health records, all of that information is really important to be kept on file. But when we look at pay information, then we know that leave records, holiday pay, all of that stuff, 6 years is the maximum for the employee. So you need to start looking at offboarding information too. It's important not to just be harboring or holding on to this information. And a lot of employers don't even realize that they've got to offboard it and that they've got to get rid of the information. And it's as simple as just deleting everything that you've got on file about this particular employee. I would personally give it 7 years and then look at deleting, just so that you have that extra bit of time. I don't like rushing to get rid of things just in case. Now, in terms of understanding exactly what this looks like in practice or in cases, there was one particular company that I thought would be worthwhile speaking about, and it was a case that dealt with the horticulture industry. So Alam Horticulture basically got pulled up for a bunch of different issues. And when it came to employment law, the issues were they weren't keeping sufficient wage and time records. They weren't keeping sufficient holiday and leave records. They also weren't paying employees for not working on a public holiday. So if that was their otherwise working day, those people weren't actually getting paid, and they weren't paying employees at least time and a half for working on the public holiday. So we've got public holiday breaches as well as wage and time record breaches. And in this case, the employer, Morshid Alam, who is the director of Alam Horticulture, was actually liable, along with the company, to pay a total of $48,000 for violating New Zealand's minimum employment standards. Yep, you heard that right. That was the employer and the company. The Employment Relations Authority imposed financial penalties on both the company and also the employer. And this is where it gets serious. The employer being the company, but then also personally holding the individual liable, who is the director of the company. So $32,000 was levied up against Alam Horticulture, and $16,000 was personally levied against Morshid Alam, the director. And these penalties, and the whole point of this, was to deter and prevent future non-compliance of employment standards. Now, what a lot of people don't realize is that wage claims are very different to personal grievance claims. When you're looking at a personal grievance that's maybe for unjustified dismissal or disadvantage, you've got 90 days there to raise that claim. Now, when it comes to a wage claim, though, the employee has up to 6 years to come after you for the incorrect payment, for the incorrect leave records, whatever it is. They have up to 6 years to do that. And that limitation and that time frame is really critical, because that means that, one, not only can the employee come after the employer well past the 90 days, the second issue is that, like in this case, they can actually come after you personally and hold you personally liable to pay back some of those wages. So it's not just a matter of, I'm the director, I'm protected behind this company. So you can see the seriousness of it. Where I would say that I see a lot of the issues is those smaller businesses. I used to see all the time that there would be random labor inspectorate audits. Maybe an employee said something and the labor inspectorates come in knocking. These are the situations where employers are just not prepared. And a lot of times they probably haven't done anything wrong. It's just that someone's come around knocking and they've not been prepared for that knock on the door. So it's really important to make sure that you are fully prepared, and that it also helps with your employees understanding what they're receiving and what they're not, so that they're not sitting there asking you 1,000 questions. They are fully aware, fully understanding, and it makes things a lot more streamlined and a lot more easy to understand. Well, I hope you found this episode informative, and if you already knew this stuff, then hopefully it was a good conversation and a bit of a refresher. If you've been enjoying these episodes, then like I said, subscribe to the podcast, give it a follow, and if you want to hear more about employment law and once a week is just not enough for you, then jump over onto LinkedIn and give me a follow, because I post some great insights there on a regular basis. Thank you so much, everyone. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.